Good evening. Hmm, I hope my voice is clear and you can see the screen. Okay. Can you see the screen? Status of courts. Okay, very good. Okay, before discussing the status of course, let's have a eyebird view on the lecture that we have completed. First, first we have studied the court structure, the development of courts, the development of law, how the law is developed over the ages. And then we have studied these court structures, civil court structure, criminal court structure, type of law. And now we are studying the area sources of law, the origin, the documents through which a law can be produced, a law can be established, right? This is the area point one, sources of law. In the sources of law, there are two main sources. There are two main sources which considered the origin of the law: case law and precedent. Case law have two branches, one common law and equity. In the case law, we actually studied how the change comes when there is introduction of equity law. We can say that equity law is basically one step addition of fairness in the practices of the common law. So this change, we call it a case law, right? What was the common law? Common law, it is the system of rigid rules. It is implemented through the judges, through the nominees of the king, who travel around the state and find out whether the orders of kings are obeyed or not, right? The common law gave compensation only to the monetary laws, but equity law introduced the concept of fairness. Fairness means it is not necessary that you only have monetary laws, but we can say that equity law says if you have no loss of money but loss of feelings, then we will we will say that the justice will be get through the equity law. Right now, what change we have through this conversion from common law to equity law? What are the changes? Changes are better procedure, which have better remedies, and on successful claims award damages. Compensation is provided. Why? To compensate the loss, to compensate the innocent party. What are the remedies? Remedies provided by equity: specific performance, do what agreed to do. Injunction. Injunction is abstain, restrict someone from wrongdoing. Ratification is the correction. Recession is the very important and technical point, which means restore in pre-contract position. Okay. Tell me, do you have any question in all four remedies? Are you clear with these 4 points? Okay, very good. The next, general rule, where equity rules, where there's a conflict between equity and common law, the rule provided by equity will prevail, will get the importance, will get the preference. Now, the second point is doctrine of judicial precedent. Doctrine of judicial precedent is based on consistency. That means state decisions. State decisions mean make a decision, stand with that decision, and follow that decision on the subsequent cases of same nature. If facts of the case are same, if the nature of the case are same, then the same decision will be applied, which were decided years ago in the same nature case, right? But if the facts are different, we will say that the same rule will not be applied because there is distinguishing facts. The rule, the precedent which is followed in the subsequent cases are called the judicial precedent, and the rule which do not follow in the subsequent cases are called the persuasive precedent. Persuasive precedent. Clear? Now, okay. We are also done with the ratio descendi. Are we done with the ratio descendi or obiter dicta, or we need to do it? We are done with the ratio descendi and obiter dicta. The ratio descendi are the facts which lead the final judgment, and obiter dictas are the statements which are said by the way, which are the statement other than the ratio descendi. Clear? Now, your homework was status of courts. Are you done with the status of court? Do you have any question in it? You can see that we have studied the vertical explanation of the code structure, but this is the horizontal explanation of the code structure. Do you have any question? Magistrate court is bound by and decision binding on. Bound by all higher courts, and its decision is binding, not even itself, because there is no smaller court than the magistrate court. County court, again, yes, county court is higher than the magistrate court, but its decisions are not binding on the magistrate court, and it is bound by all superior courts. Crown court, it is higher on the magistrate court, and its decision, and it is the crown court is bound by the all higher courts. Okay, you have any question on this structure of courts? This Court of Appeal is little technical. Okay. Court of Appeal is little technical. Court of Appeal is bound by its own decision, Supreme Court and European Court of Justice. But in some cases, Court of Appeal is not bound by bound if the exception is met. Okay. We in the coverage of the course, we will read several rules, and we will also study the exception of those rules. For example, if I will say a driver is not allowed to drive harshly, right? This is the general rule. A driver is not allowed to drive harshly, but there is an exception. Exception means if a driver drives rashly, that he may get some exception, some exception from the court. Exception from the court means relaxation from the court. For example, if there is a driver of an ambulance, that means he is allowed to drive rashly, because the purpose of driving is different. The purpose of driving is to save someone's life. So a normal driver is not, a routine driver is not allowed to drive fast rashly, but on the other hand, a driver of ambulance, a driver of fire brigade can etc can allow to drive fast and rashly, right? Because the objectives are different. So general rule and then its exception. So the concept is saying court of appeal is bound by all the its own decisions and all the senior courts, and its decision are binding on all inferior court structure. Who are the inferior court structures? Court of appeals, high court, county court, crown court, and magistrate court. And itself, how the exception? What is the exception? Exception is Court of Appeal, COA, Court of Appeal is usually bound by its own decisions and Supreme Court, right? Exception. Two previous cases conflict, difficult to decide which decision to apply. If there are two cases which are more or less similar but not similar, right? And there are two guideline decisions for that case, and you are unable to understand which guidelines to take, right? In this scenario, court of appeal will not follow the decision of the Supreme Court, right? Come again. If except general rule, Court of Appeal is usually bound by its own decision or decision of Supreme Court. But when there is a conflict between two decisions of the higher court, two decisions of the Supreme Court, and you are not know which decision to apply, then Court of Appeal will not follow the higher or its own previous case reference. Clear? Second, previous cases decision conflict with decision of Supreme Court. A case which is decided in the Supreme Court and the same nature case which is decided in the Court of Appeal. If there is a conflict in between the decision of the Court of Appeal and the decision of the Supreme Court, then obviously Court of Appeal will not follow its own decision but follow the decision of the Supreme Court. Clear? Third, previous case was made with lack of care. Lack of care. If the previous decision was not taken with care, then Supreme Court has right not to follow its own decision or the decision of Supreme Court. Is this exception is clear? When Court of Appeal will not follow its own or Supreme Court's decision. Okay. Now, we have done with the persuasive precedent. Please read it and tell me if you are not clear on it. Do you understand the persuasive precedent? Where 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 an earlier decision was made by a lower court, the judges can overrule the ratio of the earlier cases if they disagree with the lower court statement of law. Overrule. Now the new term overrule, and the outcome of the earlier judgment remains the same but will not be followed in future. Overrule mean the decision of the previous court will be remain the same, and but this decision will not be followed for the future. And reverse mean, the term reverse mean not only change the decision of the current case but also change the decision of the previous case as well. Overruling, the previous case decision will remain same but it will not be followed in future. And reverse mean the not only change the decision of the current case but also change the decision of the previous court, right? If the decision of the lower court is appealed to the higher one, the higher court may reverse. Higher court may reverse the result if they feel the lower court has wrongly interpreted the law. It is not easy to change to reverse the decision of any case. You have to prove that there is wrong interpretation of the law in the previous decision, right? So, but when we say a lower court decision can be challenged, can be appealed in the higher court, that means that is the procedure of reversing. You try to reverse. But in the overrule, you are taking the guideline from the previous case decision. So if the facts are similar, the nature is similar, you will follow that. And if the facts is not similar, then you can overrule. And reverse mean when you are making appeal for the lower court decision to the higher court, then higher court has right to change the decision of the lower court. I want you to read the persuasive precedent once again, and if you have any question, please ask. Are you clear? Okay, good. Now read this overrule and reverse. Overrule and reverse. I have already explained. Clear? Okay. Now, avoidance of a binding precedent. Avoidance of a binding precedent, when you can avoid the binding precedent. When there is a conflict of fundamental principle of law. The same case that we are talk about the first point of the Court of Appeal exception, that if there is conflict between the cases, you are not know which case to apply, then you can avoid the binding precedent. Distinguishing facts, number two, distinguishing facts, that means if the facts of the cases is not similar, then you can avoid the binding precedent. Ratio descendi obscure mean when the ratio descendi effects, when the ratio descendi is not clear. If what is the ratio descendi? The statements leading to the actual decision. If that is not clear, the ratio descendi is not clear, then you can avoid the binding precedent. Previous precedent is so much void that guidance for subsequent cases cannot be obtained. In that case, you can also avoid the binding precedent. And if the you can see there are three points which are similar to the court of appeal. The fundamental principle, the previous precedent is wide and not provide the clear guidance, and at the third, if the previous case is decided with lack of care, then you can avoid the binding precedent. Clear? Okay, what are the advantages of the precedent? It is clear and consistent. It is flexible. Details are available to match and practical. Binding precedent is made on the practical issues, and it is detailed so that the guidance for the subsequent cases can be obtained. Right? Disadvantage: there are bulk of cases, you do not understand which to follow, which rule to follow, and sometimes there are unfair precedents in which the side of the one party is taken, the decision in the favor of one party is taken, and there is unjust just there is that decision is unjust for the other party, and it restricts the discussion of the judges. For example, if you follow the decision of the previous court, then the work and the duty of the current court is restricted, and sometimes it is unfair results, because maybe the previous case decided 10 years ago, and when the situation is different and now the facts are different, but but the rules are also changed. So in this case, if you follow the 10 years previous court decision, then it will be unfair result. Clear? Okay. Legislation. Before going to the legislation, legislation is the second source of law. Legislation is the second source of law. First source of law is the case law. In the case law, we have studied different concepts. One is doctrine, common law and equity law, the shift from common law to equity law. Second, the precedent, doctrine of the judicial precedent, the court structure, the court structure, persuasive precedent, overruling and reversing, and then how we are allowed to not follow the binding precedent. Are this first source of law is clear? This first source of law is clear? Okay. Legislation. Legislation is a statute law made by the parliament. Legislation is the statute law made by the parliament. Okay. We have already studied the statute law. In the statute law, we say that there are multiple judges of different, the multiple specialists of different fields sit together and make the laws for the public, right? This is called the statute law. We elect some public representatives who sit in the parliament and decide law for the general public. This is called statute law, statutory law, which is made by the parliament, which is made by the which is made uh, by the by the representative of the general public, right? Just give me a minute. Okay. Parliament is sworn. Parliament have powers. Parliament has power to sworn mean having power. Repeal earlier statute. That means the cases, the rules already made can be repealed, can be overrule or modify, and the parliament has right to make new laws. Right? These are the powers of the parliament. Convention which limit the parliament sovereignty. No parliament can present a future parliament. Right? No parliament question the laws of no parliament can present a future parliament. Parliament work in the current times, right? Validity cannot be questioned but may be incompatible with the HRA. HRA is a Human Right Act, right? Every law made by the parliament cannot be questioned, but it can be incompatible, not compatible, not following the Human Right Act. But if the legislation, if the rules of parliament is incompatible with Human Right Act, then then a statement of incompatibility need to be issued, just to explain that why this law, this new law is incompatible, not following the Human Right Act, and this is the reason behind it. Right? So first thing, legislation where the rules for the public is decided by the public representative, where the judges, where the experts where of the different fields sit together and make the law for the general public. So the law made by the by the public representative in sitting in the parliament is called the statute law. The legislation or parliament has power to reappeal earlier statutes. The rules made in the past can be reappealed. Can be reappealed. That means if someone is not satisfied with the decision of the court, then it can be questioned, appealed in the higher court. First power. Second power, it can overrule. Overrule means the previous case decision will remain same, but in future this rule will not be followed. And modify, it can bring change in the law, and the parliament can make new laws. Right? Okay. The no parliament can present any law related to the future. It can operate in the current times. The legislation made by the parliamentarians cannot be questioned. The rule made by the public representatives cannot be questioned, but they may be incompatible, not following the Human Right Act. In this case, when a legislation is not compatible with the Human Right Act, then a statement of incompatibility need to be issued, where it explains how it is not compatible with the Human Right Act and what is the reason behind it. Clear? Interpret statute. law by their own sense, which may be consistent with the actual rule. Clear? Is this legislation is clear? Are you with me, girls? Okay. What are the types of the legislation? Public effect, general public. Private effect, specific group or individuals. Delegated legislation. Now, the delegated legislation. Delegated legislation empower a specific individual or body to produce a detailed requirement by parent act. Delegated legislation means parliament has decided the rule and then it handed over that rule to the subsequent body to follow that rule. Delegated mean to delegate the powers, to transfer the powers. Legislation, why this the concept of delegated legislation is introduced? Because there are so many cases, there are so many matters for the parliament to handle. So what the parliament do? Parliament make the laws and hand it over these laws to these different bodies to solve their problem by following those laws. For example, Employment Tribunal Act is established. Employment tribunals are established. How Parliament has decided the rules regarding to the employer and employees and their contract. But if there is any violation, they have decided the laws how to solve the dispute among the employer and employee. And to implement these rules, they have established the employment tribunal. So if there is any dispute in between employer and employee, they will go to the employment tribunal. And if that employment tribunal is unable to solve that dispute, then an appeal can be made to the court of appeal. Do you remember the hierarchy of court? You have seen the high court equivalent to the employment tribunal. Clear? And with this, I hope you are also clear with the delegated legislation. Legislations are made by the parliament, but they are sometimes in some scenario may be implemented through different bodies, different related and relevant bodies. Those are called the one example is employment tribunal. Are you clear? Now, how a rule is established? Procedure 1. First reading, it's reading. Stage 1, first reading. Of publication and induction of the agenda. No debate. Here, the problem is presented. First stage, the reading of publication, the reading of the problem. Second stage, reading, debate on the journal, insist of bill, no amendment. Bill means that particular area, that problem for whom the decision, the rule is about to make, right? First stage, reading of the agenda. Second stage, debate on the journal, insist of the bills, no amendment. In the committee's third stage, the committee stage, where the bill is examined, the pros and cons of the decision is examined by the standing committee, which is made only for the decision of this particular case. And report stage, bill is amended. It is reported, it is combined, it is written on one place, so that it is approved by the house and become the guideline for the previous become the guideline for the subsequent cases, the report stage. And at the third stage, bill is approved by the house. First stage, reading of the agenda. Second stage, debate on the agenda. Third stage, examination of the agenda by the standing committee. Third stage, whatever the conclusion of the standing committee is made, is reported, is written. And then at the last stage, the bill is presented for the approval and approved. This is how a legislation is passed. This is how a legislation is passed. Now, advantages and disadvantages. Do read the advantages and disadvantages, then I'll explain it. What are the advantages of the legislation? First, it is responsive to the public opinion. That means it change with the opinion of the public. Deal any problem, because in the parliament there are different skill sets, so they can handle any sort of problem. Carefully constructed, because there are pool of opinion for handling one problem, so it is the rule which is made is carefully constructed. And it is responded any problem in the society or case. No disadvantage mean it is detailed, because for making a precedent there are need to be all little details reported, so that the subsequent cases may get the guidance. So these are bulky, and when you analyze a bulk, then it will take time. And due to lack of time, due to lack of time or hurry in deciding a case, there may be mishandling of detail, right? Mishandling of detail due to carelessness, due to short time, and then cannot anticipate any possible situation. It is the reference of previous cases, not anticipation of the future result, future loss, right? So these are the disadvantages of the legislation. Okay, what are the delegated legislation? These are the detailed laws made by subordinate bodies, to whom power to do so has been given by the statute. I have just put the example of the employment tribunal. Delegated legislation appear in various forms. Ministers, the legislation is delegated to ministers, to local authorities, to rule of courts, professional regulations, and councils. For example, Privy Council. For example, Supreme of Court may allow the disputes of the nation to the Privy Council. This is why the Privy Council has been established. Now, what are the advantages of delegated legislation? It saves the time of parliament. It includes professional and technical opinion as well. For example, a body is introduced to handle the disputes of the chartered accountant firms. Right? Now, whenever the chartered accountant firms will solve the problem, there must be an inclusion of the technical and professional opinion. If new law or altered legislation is required, they can issue without referring back to the parliament, right? And law enacted very quickly. Delegated legislation means the law is enacted very delicately, very quickly. And disadvantage, there is lack of accountability. No one can ask anyone that why they have made this new law. Difficult to keep update because one time if parliament has made the law, there's that laws are followed for hundred of years and no one can ask. And third, power to civil servant who are democratically elected. If they are democratically elected, then obviously they will misuse their power. And delegated legislations are confused because you don't know whether you go for the parliament or for the bodies. Are these advantages and disadvantages are clear to you? Okay. Before going to yes, ma'am. Okay. Before going to the statutory interpretation, I want you to please open the detailed notes of the Hamza Academy chapter 2 and have a look on the legislation and delegated legislation. Please, please open up the notes of the Hamza Academy and have a look on the legislation and delegated legislation. And if you have any question, please come to me. You have 5 minutes for this. Please open the detailed notes of the Hamza Academy and read the legislation. Let me open the topic in front of you as well. It's page 12, legislation. Do read page 12 and 13. Yes, till the types, page 12 and 13. Please read it. Are you done with the reading? Is it clear? The concept of legislation and delegated legislation is clear. Okay, good. Now, coming on the point, statutory interpretation. First, we have studied the sources of law. There are two sources, case law and legislation. And then statutory interpretation means whatever law we made, we need to interpret that law so that the judges following that law can easily understand. So interpretation, explanation of the existing law for the guidance of the subsequent cases. This is called the concept of concept of statutory interpretation. Legislation must be interpreted correctly before judges can apply it fairly. To apply the legislation, judges may first interpret and understand it. Problem occur when the judges has difficulty interpreting the statute. There are a number of situations which might lead to our need for interpretation. Why we need statutory interpretation? Because there is ambiguity, uncertainty, unforeseeable developments, and broader terms. When a law is made, there is a difficult language is used for making that law, for interpreting that, for making in the making of that law. So we give the rules of give the rules of interpretation so that the implementers of that rule may understand it before applying it. So how they understand it? Through a statutory interpretation. And why we need the interpretation? Just because of the ambiguity, uncertainty, development, and broader term of the language used, right? There are three basic aids of interpretation. First is rule. Second is presumptions. Presumption mean assumptions. And other rule, intrinsic and extrinsic aids. Right? Now, what are the rules? There are 5 rule: literal, golden rule, mischief rule, purposive rule, and con, contextual rule. Literal rule mean literal and grammatical meaning. Golden rule mean use plain and ordinary meaning of what? Of what? Of the difficult and broader terms. Mischief chief rules. What mischief means? Act. Whichever word, whichever meaning suits on your act, apply that rule. Purposive rule mean which is the combination of literal and golden and mischief rule. That means which explain the grammatical plain and the meaning suits on the action, use that meaning. And contractual rule mean which explain the context of the rule, why we have made that rule, what is this general what is the need for this rule. So there are 5 rules. First, use the grammatical meaning. Second, use the plain meaning. Third, use the meaning which suits on your act. And third, which use the meaning which have all 1, 2, 3 characteristics. And at the last, which explains the context of the law, explain that rule. Right? So the first aid of the interpretation is rule, which have five rules: literal, golden, mischief, purposive, and contextual rules. Right? Now, the second aid is presumption. If no expression, then we can presume thing. We can assume thing. We can presume thing. We can assume thing. But presumptions are rebuttable. Rebut mean can be changed. Can be changed. Assumption mean which is not based on the reality, but we are assuming something. We are assuming something, and which is not based on the reality, and we assume that assumptions can be changed. That assumption can be changed. Now, what are the presumption? I want these are the seven assumptions. Please read them, then I'll explain one by one. Okay. A statute does not alter the existing common law, right? For example, if there is any dispute, one interpretation guides you about the alteration in the common law, and the interpretation guides you about not altering the common law. Then the court will say apply the rule which allows no alteration. For example, what they are saying, if a statute is capable of two interpretation, one involving alteration of the common law, and the other not involving, and the other one not, the later interpretation is to be preferred. First presumption. Second, every person should be compensated. One should be compensated for the loss. Statute does not reappeal the other status statutes. For example, one law of the parliament cannot reappeal in the statute again. It can go to the higher court. Not bound the crown court. Only a law effect in the UK cannot impose criminal liability without proof. Statute cannot have retrospective effect. For example, it starts from now onwards, but it has no effect. It has overruling effect, not the reversing effect. Right? Other ends, the Interpretation Act 1978 defined various terms which frequently used. Gender means singular and plural both, masculine and feminine both. So it interpret the other ends, that the Interpretation Act 1978 interpret the journal terms which can be used for making the law. Now, the intrinsic and extrinsic aids. Intrinsic aid, long title of the acts. For example, when you open a book, there is a title of the book, and then there is a preamble of the book, that why this book has been made. And then there are some interpretation section in the book which explaining the difficult terms. For example, in one page, if there is a difficult term, then this term will be started there, and the interpretation is at the end of the page or at the end of the book. Side notes, for explanation of any word, there is a side note at the left or right side of the book. So intrinsic aid is the set of books. It's a set of long titles. Preamble means why this law has been made, and interpretation of sections of the act, which act is used and what is the meaning of that act. And side notes mean explanation of different key terms explained on the left or right side of the book. So guidance for the act given, preamble of the act, given understanding about the objective of the act, interpretation section of the act, long title of the act, self-explanatory, and side notes. These are the interpretation, how, what are the sources are used for the interpretation, and what are the presumptions when you are interpreting the law. Extrinsic aids mean these are the law reports and the journal which is periodically developed and sent to the parliamentarians for the upgradation of their knowledge. Law reports mean when a law is made, a proper report is designed, and that report include the parties, the argument of parties, the ratio descendais in and the obiter dictas of the case, and then on the basis of the ratio descendai, the decision which will become the rule for the subsequent cases. Which will become the rule for the subsequent cases. Now, Human Right Act. Impact of the human legislation. Human Right Acts impact on the new legislation, on the statutory interpretation, and the common law. For the legislation, I have already explained that the new legislation may incompatible with the Human Right Act. In that situation, a statement of compatibility with Human Right Act must be issued. If incompatible, then statement of effect made. First, whenever a new legislation is made, it should be compatible with the Human Right Act. So if it is compatible, then statement of compatibility will be issued. And if it is not incompatible, if it is incompatible, then statement of effect. If it is not compatible with the Human Right Act, then what is the reason and what is the effect of it? Second, statutory imputation. If there is any conflict between the Human Right Act and statutory interpretation, then again statement of compatibility will be issued. Statement of compatibility interpreted according or by protecting Human Right Act. What the statutory interpretation says, if there is any interpretation of law, then this interpretation must be compatible with the Human Right Act. And at the end, the impact on the Human Right Act, if there is a common law which is if there is a conflict between Human Right Act and common law, then Human Right Act will be preferred. First, common law. If there is any conflict between common law and Human Right Act, common law will be Human Right Act will be prevail, will get the preference. For the statutory interpretation, which whatever statutory interpretation is made, it should be compatible and by protecting the Human Right Act. And if there is any legislation, this legislation must be compatible with the Human Right Act. If it is not compatible, then statement of reason will be issued, and the impact of the incompatibility will be issued. Clear? Are you clear? Okay. Coming to the detailed notes of the Hamzah Academy. I want you to take the 5 minutes, 10 minutes. Take the 10 minutes and read and have a bird eye view on page uh, 13, end of the 13, where the legislation ends, 13, 14, and 15. Yes. 13, 14, and 15. Take the 10 minutes and go through the page 13, 14, and 15. Then we will start the practice of this area. Few questions we will practice few question today and few in the upcoming class. Please take the 10 minutes and have a bird's eye view on the page 13, 14, and 15 of the Hamzah Academy. Are you done? Are you done with the reading? Do you have any question? If it is clear, let's go for the question. Question 2.1. Which of the following is a statement by a judge that is the basis for their decision and is what becomes binding on future judges? Come on, can you see the screen? Question 2.1. No, the terms are not new. Obiter dicta are the statements we are just done. We are done this the term obiter dicta and ratio descent die in the last lecture, and I have also explained today. Per incurrum mean lack of care. Obiter dicta are the statements which are said by the way, and ratio descendi are the statements which lead towards the final judgment. Right here in the notes, in the short notes, see ratio descendi and obiter dicta. Shiny, can you see the ratio descendi and obiter dicta? Ratio descendi are the statements which lead towards the final decision, and obiter dicta are the statements which are said by the way, and per incurrum mean thing which is decided with lack of care. Yeah. This, see, per incurrum mean decided with lack of care. Clear? Shiny, are you clear? Okay, you can ask the question. If you are not clear, you can ask the question. All right. You have the see, whatever you see, you have three types of sources of your study. First, the very short notes which you see on your screen, which I explain. right? After the short notes, you have the detailed Hamzah Academy notes in which you see the complete detail of the concepts. And at the third, you have a practice kit that we are practicing, right? So the term ratio descendi and orbiter dicta we have done in the previous lecture, and I assume whenever you revise the detailed notes of the Hamza Academy, you read the terms in detail, and I assume if you have any question you can ask, right? Now, tell me if this term orbiter dicta and ratio descendi is clear to you. Ratio in simple, you read it on the Hamza Academy notes, detailed notes, or the short notes which are on your screen, right? Obviously, in the class we have very short time. We cannot read each and every line of the detailed notes. So, from those detailed notes, I have extracted the points which I elaborate in the class. Are you clear now? Okay, we can also have this pattern. Whatever we study today, we practice this in the next class. I have just started this practice that whatever we study today, we will do the practice question in the same class so that we will revise the concepts once again. But if you feel it difficult, then we can have this practice that we read it in the class and practice the today's lecture in the upcoming class. What is suitable for you? Fine. Okay, you want to do the practice today, or you want to read it in the during the week and then practice? What is your suitable pattern? Okay, whatever we have studied today, are you clear with those points? Okay, good. Okay, okay, fine. That would be fine for me as well. Uh, okay. Now, uh, just be with me for 5 minutes, and we'll revise the points we have studied. Okay. Okay. Let's start from the start. It is just to memorize you so that we understand all the points. Okay. Be with me for 5 minutes, and we're gonna revise the total sources of law. Okay, sources of law. Okay, first, sources of law. Basically, there are three main things which we need to understand while studying the English legal system. The very first topic is English legal system, and for that we have first studied how the law is developed. That means over the very 1,000 years thousand years ago, the law is there is no rule of life. Then people think we need a rule of life, we need control mechanism, we need social control mechanism so that we can live our life by laws. So they have two types of mechanism. First, social control mechanism. Second, informal control mechanism. Formal control mechanism, informal control mechanism. Formal mechanism is law, informal mechanism is ethics. Law is thing which you have to follow, which you have to follow. And informal control mechanism has ethics. You follow, it's better, right? Okay. Then there are types of law. Very first type of law is common law, which compensate the monetary laws only, which introduced in the royal courts, where with the order of king. The representatives of the king or the judges travel around the world, around the state of the king, and observe whether the rules of king is followed or not, right? Then if they find anyone not following the orders of the king, they impose punishments. Then one step ahead, the concept of equity is introduced. Equity introduced the fairness. It deal not on the monetary laws but also the laws of feelings, the laws of intentions. Then equity law is bring the new changes, new remedy. What is the remedy? Remedy is something which is the compensation of the loss. Compensation of the loss. If my car light is broken by accident, then the payment against that car light will compensate me, will recover my loss, right? Then statute law mean law which is made by the parliamentarians, persons elected by public. Why we need the statute law? We need the pool of expertise, pool of skill sets which sit together at one place at the parliament and decide the law for the public and covering all the branches of the disputes, right? Then we have studied this private and the public and private law. Private law which affects the small individuals, small group, small company, and public law which affect the large companies. Then public law is the branch of the civil law, and public criminal law is the branch of the public law, and private law is the branch of the civil law. Criminal law, public law. Civil law, private law, right? Again, criminal affects the whole public, and private law affect the small group of small group, small companies, small individuals. Clear? Are you clear till now? And then we have studied the court structure, the magistrate court, crown court, county court, high court, court of appeal, supreme court, privy council, convention of human rights, European court of justice, right? These are the court structure. In the court structure, the cases are presented to court in a pyramid. They are solved in a pyramid. A bulk of the cases came to the magistrate court and different courts designed to solve the problem of different types and different nature. Different type and different nature. Magistrate court deals with the family matter, then county court, then the crown court, then the high court, and then at the there is civil court structure and criminal court structure, and the cases are solved in the form of pyramid. Bulk of cases came in different courts according to their nature, and then they shrink to the top, and at the top there is a supreme court, and supreme court only deal very rare nature cases, right? When we are done with the court structure, civil court structure and criminal court structure, we need to understand the sources of law. What are the source through which we have made the laws? What are the source through which we have made the law? Are you with me till this time? Till here, do you feel any question till this? You do you have any question? Okay. Then we have studied the sources of law. Source with the help of those we establish the law. There are two sources. First is the case law. Second is the legislation. In the case law, at the first stage, we have studied the shift of common law to equity law. shift of common law to equity law, which have four remedies, four better remedies for the innocent party. First, better procedure. Second, better procedure. Then to impose something, that whatever is specific performance, injunction, recession. And recession is the very important term in which you restore the parties in the pre recession is the term in which you restore the party in a pre-contract position, in the position the party would have been if contract never made, if the contract never made. So what are the remedies available when there is a shift from common law to equity law? Specific performance, injunction, ratification is the alteration of the document, and recession. And after the recession, if there is a conflict between common law and equity law will be prevail. Then we have studied the term doctrine of judicial precedent, which is a rule which is made on the basis of consistency. Maxim stare decisis. Maxim stare decisis is a technical term which means make a decision and stand by that decision. That means if the same nature case occurs, if the same nature case occurs in the future, the same decision will be applied. This is called consistency and doctrine of judicial precedent, which apply on the same nature cases. And the cases which are not similar, which has not same nature, these decisions are not followed in the upcoming cases. That means these are persuasive precedent. Any rule which follow in the subsequent cases, judicial precedent. Any rule which do not follow in the later cases, these are called the persuasive precedent. Why we do not follow the binding precedent in the future? If it is made on four conditions. First, it conflicts with the previous case, higher court. It is made with lack of care, pre incurrum. Let me explain. Okay, when it has conflict with the law, distinguishing fact, where ratio descendi is not clear, where previous precedent is so wide that it is unable to provide the guidance, and when the previous case is made per incurrum, carelessly, right? Okay, then we have studied the term court structure, which court the decision of the which court is binding on the which court. And then we have studied the term overrule and reverse. Overrule mean the decision of the previous case will remain same, and the subsequent case have the new decision. And reverse mean you are not only change the decision of the current case, but also change the decision of the previous case. Overrule mean reverse mean the scenario of appeal of the decision of the lower case to the higher case. Clear? This is clear till now? The case law is clear? Okay. Then the second source of law is the legislation. The second source of law is the legislation. Legislation means the rule, the law which is made in the parliament. And parliament is sovereign, has power to make new laws, to overrule the laws, but it has no power to reverse the laws, right? And parliament works in current times. Then there is a concept of delegation of power, which means you delegate the power, you make the law and delegate the power to implement those laws by some other authorities. And the parliament delegate the power to the minister, to the local bodies, or to the major stakeholders of the country. Clear? Then when the law is made through the case law and the legislation, then we need to interpret that law so that the implementators of that law understand that law and implement the law carefully. So there are 5 rules. First, golden literal, plain, use the grammatical meaning, use the plain meaning, use the purpose, mischief rule, use the meaning whichever whatever suits on your act, and then the purposive rule, and then the contextual rule. When you are explaining the law, you assume something, you take assumptions. These assumptions are rebuttable, can be changed because these are assumptions, so these can be changed. Assumption means, for example, this law is only applicable in the UK. This law is only applicable to the UK, and this law is not for any illegal activity. Clear? So what are the presumptions? See, every person should be compensated. Statute does not repeal the statute, not bound the crown court, only law effect in the UK, and cannot impose criminal liability without proof, and statute cannot have retrospective effect. Prospective effect mean from now onwards. Retrospective mean not only the current but the previous as well, from the history. Retrospective mean from the history to future, and prospective mean from the present time to future. Clear? So it is had no retrospective effect, that means it has prospective effect. And then there are different terminal, the Interpretation Act 1978, which interpret the technical terms. For example, gender. For example, gender mean masculine and feminine, singular and plural, right? And color, and the different terms which are which we generally use, and which represent male and female both, right? Okay. And after the presumptions, after the rules, after the presumptions, there are some books, there are some law reports, there are some long title books, there are some keynotes which help for interpretation of the law. When we interpret the law, there is an impact of a very important element on which the European Convention create the consensus, which is Human Rights Act. Whatever you make, if you make new laws, if there is a common law, then it should not be incompatible with the Human Rights Act. It should not conflict the Human Rights Act. If there is any conflict between common law and Human Rights Act, then Human Rights Act will prevail. And then if you make any new legislation, any new law, this law should be compatible with the Human Rights Act. But if it is not compatible with the Human Rights Act, then then the statement of incompatibility will be issued, why this is incompatible and what is the impact of the incompatibility. And at the third, when you interpret the law, then every interpretation must be incompatible with must be compatible with the Human Rights Act. Act. If it is, there is no incompatibility, then a statement of incompatibility will be issued, and the effect of the incompatibility will be explained. So this is the total area of English legal system. This first part of your syllabus, English legal system, is clear today. And in the next class, we will definitely practice the remaining chapter. This is just give me a minute. Yes, the chapter 2 of your exam kit we will practice in the next question. Sources of law 2.1, 2.1 to 2.15. Okay. Now we have to start the next area of our syllabus, which is law of obligation. You want me to start right now, or you want to have a break? Are you with me, girls? Okay. Okay. See, the syllabus in the syllabus we are done with the first area, which is A, essential element of English legal system. In the English legal system, essential elements of the English legal system, we are done with the law and the legal system and the sources of law. The next area is part B, which is the law of obligation, in which we have four major areas. First is formation of contract, how the contract is formed. Second, the content of the contract, which are the contents, for example, the agreement, the consideration, the intention to create, how, what are the key elements of the contract. And then breach of the contract, how a contract can be breached. Obviously, when there is a contract in between two parties, if one deny from doing what he has or she has agreed, then there is a breach of contract. And if a contract is breached, what remedies, what compensation is available to the innocent party, the remedies. And the law of tort and professional negligence. Tort is any act which can harm your neighbor, and neighbor is the person not only living next to you, but neighbor is anyone who can be affected by your act. So tort is any your act which can affect your neighbor. And professional negligence mean it is, for example, a company, a person who for his personal investment seek information, seek guideline for an accountant and an auditor. So what the individual is doing, he is relying on the competency of someone professional. So if that professional now negligently treat that individual, then that professional can be claimed under the law of tort, right? So this is the small introduction of our new area, which is law of obligation, in which we are going to study the formation of contract. Okay, Can you see the screen? Formation of contract. Okay. What is a formation of contract? Okay. We, in our routine lives, deal with each other is called the contract. Maybe we all daily enter into a contract, perform our obligation, perform our obligation, and discharge that contract. Discharge that contract mean mean complete that, complete the terms and condition you agreed. For example, if you are a student, right? You are a student, you go to your college, study there, and came home. This is also performance of your contract. Which contract? Which has been made at the time of your admission at the college, right? uh, if you need some grocery, if you need some grocery for your home, you go to the market, you buy the grocery, you pay for that grocery and bring that grocery to home. That action is also on the basis of a contract. You live in a home, you pay rent against that home, you pay utility bills. When you are paying the rent, that is also a contract that you are performing. When you pay the utility bills of your home, then it is also a type of contract. How? Let me explain from my very first example, which is you are going to college. Okay. If you want to study, you go to a coaching center there, and before going to the coaching center, uh, in a new one fine morning, you see a ad of an institution, of the institution about some programs which they are teaching. So you see one of that program and then go to the then go to that coaching center. When you went to that coaching center, you see there are different program and courses which that coaching center introduces, which that coaching center teaches to the students. You select one of them, and and you ask about the tenure, number of classes, the fees against that course. The the owner of that coaching center give you all the details. You agree on the details and you fill a student admission form. When you fill the form, then you will be given a invoice. When you pay that invoice, a contract has been made. How? When you see the ad, this is invitation to treat, right? When you go to the when you go to the coaching center and see the display of programs, that is information. That is information. And then you ask from the owner about the programs, that is request for information. When you show your willingness to study in one of that program, that is your offer, which that coaching center owner accepts by giving you invoice. That is his acceptance. When he accepts, then you pay the fees. So this is consideration. Now the contract between you and your coaching center is made. First you offer, which he accepts. Second, then when someone offer and second accept, this is called the agreement. Now the agreement should be supported by consideration. Reason. What is the reason? You want to get some education, and what is the reason? of the coaching center owner, he wants to earn some money. So there must be a reason behind the contract. There must be a reason behind the contract. This is the consideration reason. And and then intention. What is the intention of the student and the college owner? Right, these are the intention. If we legally want to, if we intended to legally bind each other, then this is a legally binding contract. Legally binding contract mean a contract which is enforceable by court. Okay, the student form that you have filled is the form of terms and conditions. Is all the terms and conditions written on the form is the content of the contract. Okay, this is one example. Second example, you want grocery for your home, right? You want grocery for your home. When you enter in the mall, in the grocery shop, you see multiple items displayed on the shelves. So this display of item is in the technical or in the law term is called the invitation to treat. Okay, when you get your selected items and get that selected item to the cash counter, right, to buy them. So this is your offer that you want to buy these items. And when the counterman enter these item in the invoice and give you the invoice, this is his intention, is acceptance. Your offer when you get the things on the counter, and his acceptance when he give you the invoice for the payment, right? So see, when you buy the things, you pay the money. So your consideration is the grocery, and the consideration of the grocery shop is the money. So these are the types of contract we daily enter into, right? But we do not know the technical terms of our actions. So in this area, this is where the previous area, the English legal system is little dry area, is based on the concepts and the dry discussion. But this is very interesting area that we understand with the help of real life example. For example, see, we entered into a contract, and in this area we are just going to give those terms a very the legal those actions are daily actions are legal term. See, maybe you are also employee in some companies. So if you are employee, you have given an appointment letter, and on the employment letter various terms and conditions are written, right? Various clauses are written. So this employment, your employment is also a type of contract with your employer. So we can say that a contract is a very general term. A contract is an act of two persons who have same objective. So same objective. A contract is a legally binding act is the act of our routine lives to whom we are going to give the technical terms. Now, if I'll explain what is a contract, how it come into existence, then the answer would be a valid contract is a legally binding agreement formed by the mutual consent of two parties. That means if you want to form a contract, that contract must be one, valid; two, legally binding. That means enforceable in the courts. Legally binding mean if one of the party deny to perform its obligation, then the other party has right to go to the court and enforce the party to perform their act. Formed by mutual consent. Mutual consent mean of two parties. Mutual consent mean which genuinely agreed without any pressure. Two parties mean two persons. That means a contract can be made between two parties. Two parties can be two individual and two parties can be two companies, right? So what is a contract? A contract is a valid contract, legally binding, formed by mutual consent and two parties. Now, these four terms are explained here. See, legal binding contract, mutual consent of two parties, validity of the contract and other factor affecting the modern contracts. Okay. Now, legally binding contract. Parties intention, parties intention to perform act what they have decided. If one party will not discharge its obligation, other party has right to go to court. This is called enforcement of contract. Though court will will not enforce guilty party to perform its duty, what he she agrees to do so. Do so. Okay. This is the typo error here. It's will. Though the court will enforce guilty party to perform its duties, what he or she agrees to do so. You null, this is the typo error, and instead of this, there is a word will. Okay. What is legally binding contract? I'll give you the example. For example, I am going to buy a car with from my friends. Okay. What is the we have made the arrangement that the I will pay the advance and then my friend will carry the some maintenance work of the car from that advance, and when the maintenance will be done I will make the full payment and get the car. Okay, when I pay the advance my friend carry out the maintenance work to the car. When he carried that work he refused to sell car to me. Okay, now in the opinion of court, in the opinion of court, two parties, me and my friend, are the party to the contract. And according to our contract, I was supposed to pay the advance, and from the advance, my friend is supposed to get the repair work done to the car. One he done that work, he refused to sell the car to me. Now, in the opinion of court, I am an innocent party and I should be compensated for my loss. One loss, which the money I have paid as advance, which my friend utilized, and secondly, my friend denied to sell his car to me, which he has promised, which he has promised. So, what the court will say that me and my friend has a legally binding contract. That means now the court will intervene on my request and ask my friend to sell the car to me because I have already paid the advance, and before that advance my friend promised to sell his car to me. Now he is not allowed to sell that car to anyone else, or he has not allowed to refuse to sell that car to me either. Clear? Legally binding contract mean which has some legal existence in the eyes of court, which has some legal existence in eyes of court. Legally binding contract which is legally binding, which can be enforced legally, which can be enforced through court, which can be binding through court. Clear? This legally binding contract is clear when the court intervene and give the justice to the innocent party. Okay, girls, this legally binding contract is clear. Okay. The next term. The next term is mutual consent. Mutual consent means consenting minds. Two-person agree to do one thing. I am willing to buy the car and my friend is willing to sell the car. So I am willingly agree to buy the car and he is willingly agree to sell the car. Mutual consent. Who agree to do one action or one outcome. One action or one outcome. My purpose is to get the car and my friend's purpose is to sell the car. So our combined and mutual purpose is the sale and purchase of the car. So consenting mind, which consent for one action, which consent for one action or outcome. Now, third point, validity of a contract. Validity means the contract must be valid, and there are 6 factors which make a contract valid. First, capacity, then legality, then minor, then content, then genuine consent, and at the end, form. At the end, form. Okay, let's read these validity factors one by one. The first factor is capacity. That means he or she is authorized to do so or has power to make a contract. Example, I am accountant, then I am not authorized for corporate contracts, but a finance director has the capacity to make corporate contracts. Capacity means the person who is making the contract has the capacity, has the authorization to sell that car or not. For example, I am living with my father and with my 3 more siblings, and the house in which we are living is on the name of my father. So I am not authorized to sell my father's home to anyone else without the permission of my father. So if I do so, the court will say I have no authority, I have no capacity to sell this house which is not in my entitlement. But my father, who is the owner of the house, can sell it. So you understand the capacity. Second, mental capacity means the person who is making the contract should be in proper mental capacity, right? Should intoxicated mean the person who is making the contract should not be drunk, should not be in drunk, but he should be in his proper senses when making the contract. Mental capacity mean he is a proper healthy person. Mental capacity mean he is mentally proper and healthy to make a contract. And intoxicated mean along with mental health he should not be drunk. So the capacity, a person who can make the contract should be in the proper, has the authorization, has proper mental capacity, and should not be intoxicated. So if a person who make the contract with this capacity, the contract, that contract will be considered valid, right? Legal. Second point is legality. Legality means the contract should be about the legal act. For example, the sale or purchase of drug in the UK jurisdiction is not legal. So if any contract is made uh, for the drugs, then it should not be valid in the eyes of court. Minor, any person who is below 18 cannot enter into any contract except necessities. A minor can make contract for its necessities but cannot enter into any other contract. Clear? This legality, minor, and capacity is clear. Read it. Okay, good. Content. Content means the terms and condition. Content mean terms and condition. The content of the contract, the terms and condition of the contract can be expressed. Express mean it is by words or in writing. For example, if I want to buy a car, I may by words or by expression or in writing may express my wish about car. For example, I want your car, but the color of the car should be red. The interior of the car should be brown. So these are the terms which I am expressing in words or in writing. But the other content is the employed. The terms can be expressed or employed. I am buying the car, I am expressing my wish about color and interior, but whether I will talk it or not, but the car should be in running position. The car should be in a position to assist me from traveling from one place to an other. So it is employed that I am gonna buy the car for my traveling. If this car is not fit for the traveling, the contract will not be considered valid. So we see that the terms of the contract are express and employed. Express terms mean which we express by words or in writing, and employed terms mean which we do not express, but it is understood that this condition should be met. For example, if I buy a flat on 70th floor, then whatever the case is, it is understood that I cannot go to my flat on daily basis by stairs. So a lift is an employed to go to the 70th floor. So in the contract, there are some express terms and there are some employed terms. I want you to please read the content and tell me if you are not clear. Clear? Now, genuine consent. Genuine consent means when you are entering into a contract, there should not be any pressure. You are entering into a contract by your own will. That means if the genuine consent mean mistake, misrepresentation by. So this 1952, the model of the car is my representation. Maybe my friend wants to buy the car of 1998, but he may not be interested in the car of 1952. So if I misrepresent, the consent of the other party is not genuine. It is misleading. So misrepresentation or mistake, then this contract will not be considered valid. Undue influence, undue influence who is entering into a contract should be entered by its will. If I want a car, but it is not necessary for me that I should buy this car from my friend, from any of my on the basis of genuine consent, not with any undue influence. Form to be in writing, right? Some contracts are verbal, oral, and some are in writing. But contract do not usually need to be in writing. But these three types of contract must be in writing: contract by deed, contract in writing, and contract evidenced in the writing. So the Later to the contract in writing and contract evidence in writing must be in writing. What are these? Contract by deed are the special contract. These contract must be written, signed and witnessed. Example, lease, transfer of legal estate or mortgage, and a promise not supported by consideration. If you are running a charity, you are running, see, whenever we make a contract, there is an interest of both parties. There is interest of both parties. When one party is making a contract without any interest, then this contract should be indeed. For example, if you are giving some money, whenever you give some money to someone else, then this is by the view of getting or generating profit. But if you are giving the money to a charity, you will not get anything in the return. So if you are waiving your right, then you have to give it in a writing that you are giving it this money as a charity. So this type of contract must be by deed. By deed mean in writing, signed and witnessed. Second, the contract which must be in writing are transfer of shares and bill of exchange. Transfer of shares and bill of exchange, these are in writing. And contract evidence in writing, they are in writing and must be supported by evidence. For example, if I am selling my house, then this transaction of sale of my house should be supported by the papers of my house. This contract will not be considered valid if I am not having the papers of the house, because without those papers I cannot sell my house. Clear? Are you clear? Okay. I want you can you see the chapter 3 formation of the contract from the Hamzah Academy? Please read it, which is on your screens. Definition of the contract, essentials of a contract, and then validity factors. Definition, essentials of a contract, and validity factors. Are you done with the reading? Are you clear? Okay, girls, are you done with the reading? Are you clear? Okay. What what our new area, the essentials of a valid contract will move around these three factors. These three factors. The very first factor is element, which has two things: offer and acceptance, right? And then after the agreement, the other thing is consideration. Consideration is the reason, is the interest of one party and the second party, which induce both parties to enter into a valid contract, right? Consideration is the reason, is the interest of both party which make them to enter into a contract. Then intention to create legal relation. Intention means whether the parties who are going to enter into a contract has intention to be binding into a legal contract or not. Intention to create legal relationship means if your mother promises you to buy you a phone if you pass your exam, then and later if you pass your exam and your mother did not pay any attention to her promise, then obviously you will not bring your mother into the court for the discharge of her promise, right? So the parties who are entering into a contract, what is their relation? What is their relation? Whether they want to make the contract binding or not. So if your husband, if your husband promised you to buy some jewelry and later he denied due to the financial crisis, then what it means? Do you bring your husband to the court? So there are some type of contracts in which the intention of parties for against the promise is not binding. See, now our next three lectures will move around these three terms: the agreement, the consideration, the intention to create legal relationship. Agreement means agreement has two elements: offer and acceptance. And consideration has has the in consideration is the reason, is the is the interest of the parties which make them to enter into a valid contract. And intention to create legal relationship, intention to create legal relationship is the intention of the parties whether they are they want to bind the other party into the legal relation or not. Clear? Okay, girls, do you have any question till here? Because I think uh, this is enough for today. I cannot start the next topic of the modern factors, because if I start that topic, I need another 30 minutes to wind it up. So I think this is enough for today, and I want you to please go through the Hamzah Academy, the short notes which you have seen on your screen, and read out the detailed notes of Hamzah Academy before the next class. Because in the next class, first we will practice the chapter 2 of the English legal system, and then we will resume our lecture from here. Okay. Okay, let me share you with the and during the previous week you didn't ask any question from me which make me understand two things: whether everything is very clear to you that there is no need to ask any question, and nothing the second maybe nothing, there is not, you understand nothing, that's why you didn't ask any question. I was expecting that during the week you will ask some question from me that, ma'am, we do not understand this thing, we do not understand this thing. So please be in touch with me during the week so that I can have an expression that you are understanding whatever I am delivering. So be in interaction with me during the week and during the class, because your interaction is very important for me, right? Okay, now give me a minute so that I can share the lecture 2 with you. It's about to connect. Just give me a minute. Come on, come on, come on, come on. Okay, I hope you get the notes or lecture short notes. Uh, at uh, at this time, if you try to map the every chapter and the terms, that it will be difficult, because we have just completed our first area, which have only 10% of the examable work, right? So I will not suggest you. Yes, the area you have studied till now, the English legal system, you must mention, you must mark the technical words, technical terms, and memorize the meaning of them. Yes, it will be helpful, because simply the examiner will ask when will why I was interested to practice the chapter 2 in today's class. Actually, this is the answer of your this concern. uh, yes, we do study some technical words and technical terms in our syllabus, and this is just a start. The first area that we have started is English legal system. Fine. In this area, we have few technical terms that we need to summarize and need to memorize, because in this area examiner directly asks the questions. For example, today we have studied the Court of Appeal, exceptions of the Court of Appeal. Examiner may ask which of the following is not the exception of the Court of Appeal? Or the examiner may ask, what is the meaning of the maxim stare decisis out of the following option? So the expectation of the examiner is that you understand, you memorize the technical terms, right? So, but it is just a start. So not to confuse, not to get panic. Yes, your idea is very good. Make a summary and memorize it. Okay, what is the first is, I just want you, why, what is the purpose of practicing the questions in the same clause was, I just want to repeat those terms again. For example, if once I have explained the concept of exceptions of the Court of Appeal, and at the same time after 5 minutes if I am giving you a question which asks about the exceptions of the Court of Appeal, then it is a different impact, right? It is a different impact. Once I have explained the concept, and then after 10 to 15 minutes, I am I am interpreting how examiner can ask this question, this topic, right? So actually that was my objective, but your strategy is also valid. How can we, if we practice the question in the same class, then it will create confusion for you. So I understand your point of view and we will practice in the next class. Don't you worry about it. In every class I will repeat the technical terms of that area, so that so many time you hear that terms, you will memorize them. Okay, madam used to recall these terms again. This recalling will memorize you, right? First thing. Second thing is, what is the objective of extracting short notes from the detailed notes? Okay, detailed notes is your knowledge and currently you have time in your exam, but once you have completed your whole syllabus and when you have to revise your syllabus before practicing and other bulk of questions, you need to quickly revise your concepts. At that time you will not have the time to revise all detailed notes. So what you will need, you need a short notes, which are I am showing on your screens. You can say this is my work on your notes, which I'm sharing with you, so that whenever you want to have a quick recall, then you can open these short notes and read them. So these short notes have all technical terms in it, right? All technical terms in it. You can see these are the summary of your details note that will help you out, not during the coverage of your syllabus, but at the time when you have covered all your syllabus and when you are ready to appear in your exam and you have to practice practice the exams, practice the sample exams. So this is the ideology behind the short notes and the detailed notes. I hope these are beneficial for you. And if you need any other material from my side for the practice, for the revision, I will try to share some videos in the during the week with you as well, which explain these technical terms. This is just the ideology of memorizing the things. Why I am repeating the terms with different patterns, with different notes, and with different techniques, so that you memorize them. Clear? Okay. Thank you very much. And it is helpful. It is just oh, no issues at all. We will practice in the next class. No issues at all. Actually, this class is for the facilitation of you. If you are comfortable with that, I am also comfortable with that. And I really like your feedback on that. Thank you very much. Right? Thank you. Thank you very much. Goodbye from my side. Have a very blessed week ahead. Goodbye. Okay, goodbye.